Welcome to Immigrate.center. Your journey starts here.
Understanding the employment contract in Germany, a guide for immigrants. If you are planning to move to Germany and work there, it is important to understand the basics of German employment law. Particularly relevant is the understanding of the employment contract, which outlines the terms of your employment. This article will discuss in detail the various aspects of the employment contract in Germany. Difference between employment contract and employment relationship. In Germany, there is a significant difference between an employment contract and an employment relationship. The employment contract is a legally binding document that sets out the terms and conditions of employment between an employer and an employee. This document governs both the rights and obligations of both parties. On the other hand, an employment relationship refers to the actual situation where an employee provides services for an employer. It generally starts with the commencement of work carried out based on the employment contract. The employment contract forms the basis for the employment relationship, which is established through the actual performance of work. Types of employment contracts in Germany. There are several types of employment contracts in Germany. These are: permanent employment contract. This is an employment contract without a fixed end date. As long as neither party terminates the contract, it remains in force. Fixed-term employment contract. This is an employment contract with a fixed end date. Upon expiration of this period, the contract automatically ends. Part-time contract. In this contract, the employee works fewer hours than a full-time employee. Minor employment/mini job. This is an employment where the employee does not earn more than 450 euros per month. Contents of a German employment contract. A German employment contract should contain certain essential information, such as names and addresses of the employer and the employee, starting date of the employment relationship. In case of fixed-term contracts, duration of the fixed term, description of the duties to be performed, workplace, working hours, amount of salary and any additional benefits, holiday entitlement, notice periods. Unacceptable clauses in a German employment contract. In Germany, there are certain clauses that cannot be included in an employment contract. These include, among others, clauses that deprive the employee of basic rights, clauses that unduly disadvantage the employee, clauses that violate the prohibition of discrimination. Validity of an employment contract in Germany. An employment contract in Germany is valid if it has been signed by both parties and meets the legal requirements. The contract can be concluded orally or in writing, although the written form is highly recommended as it provides clear evidence of the conditions of employment. Salary payment in Germany. In Germany, salary must be paid by the last day of the month in which the work was performed, unless otherwise stipulated in the employment contract. Understanding the German employment contract is of paramount importance to know your rights and obligations as an employee in Germany. With this information, you are well equipped to understand and navigate your future employment contract in Germany.